talk today a little bit about the law surrounding benefit fraud. Now, the legislation surrounding this is contained in an Act of Parliament from 1992, the Social Security Administration Act. That legislation sets out two principal offences of benefit fraud, Section 112 and Section 111. These offences are the basis for nearly all prosecutions brought under Social Security legislation. So, for example, prosecutions brought by the Department for Work and Pensions for fraud or alleged fraud connected with income support, job seekers allowance, universal credit, matters of that nature, and also prosecutions brought by local authorities for example, claiming incorrectly for housing benefit, matters of that nature. Now, the legislation, as I said, there are two distinct offences, Section 112 and Section 112A, and the difference in those offences relates to intention. The more serious offence is Section 111A. That says that a person commits benefit fraud basically if they intend to do so. Section 112, by comparison, it's possible to simply be reckless, not intend to go out to commit benefit fraud but still do so. Now, Section 112, an offence can only be heard in the magistrate's court. That means in turn that the maximum sentence that any court can impose for one offence can be no more than 6 months imprisonment and or a £5,000 fine. Section 111A, by comparison, that's an either way offence, so that can be heard either in the magistrate's court or in the Crown Court. The decision on whether to have a matter heard at the magistrate's court or the Crown Court is contained within mode of trial. Now, what that means is you go to court and plead either guilty or not guilty or give no indication of plea. If you plead guilty, then the magistrates will consider the facts of the matter and decide whether their sentencing powers, no more than 6 months custody or £5,000 fine, are sufficient. If they think that it's insufficient, they can commit for sentence to the Crown Court. If there's a not guilty plea or no indication of plea, then the magistrates will hear from the prosecution, hear the prosecution's representations as to suitability for trial, and the magistrates will then decide whether to accept jurisdiction or not. If they decline jurisdiction, that's the end of it, the matter goes to the Crown Court. If they accept jurisdiction, it is then the defendant's choice whether or not to accept to be heard, to be tried in the magistrate's court, or rather to elect to go to Crown Court. Now, there are advantages and disadvantages of both. The perceived advantage of going to the magistrate's court is that it is perceived to be quicker, to be less formal, to be less stressful, and it's perceived to be less costly. The disadvantage, perhaps perceived to be in the magistrate's court, is that perhaps it's more likely, some would say, to result in a guilty verdict. The reason for that is that magistrates regularly attend court and perhaps become jaded with the process and perhaps become more likely to convict. Also, of course, you've only got to persuade 2 out of 3 magistrates of your guilt, and that's a guilty verdict. You don't know whether the magistrates have decided on a 2-to-1 verdict or on the majority. Now, in comparison with that, Crown Court, a trial is heard by a jury. The decision of guilt or innocence is decided by a jury, and in most instances a judge will try to get a universal verdict from the jury, one on which all 12 are agreed, and frequently it might be thought that getting 12 people to agree on any subject is quite difficult, and therefore if you don't have a universal verdict, if you have a hung jury or a split verdict or something of that nature, it perhaps makes conviction less likely. Also, of course, members of the jury are simply lay people selected at random with little or no experience of the criminal justice system, and perhaps more likely to give a person the benefit of the doubt than perhaps magistrates might do. That's a matter of conjecture and opinion. Now, the issue then is to decide whether to be heard in the Magistrates' Court or the Crown Court. Remember, the Crown Court sentencing powers, the judges have far greater sentencing powers than the Magistrates' Court, and if there's a conviction at Crown Court, having chosen to go to Crown Court rather than be heard in the Magistrates' Court, there's a possibility that the judge wouldn't be particularly lenient when either coming to sentence or also in deciding on prosecution costs. So that's section 111A. Section 112, it has to be heard in the Magistrates' Court. Of course, if there's a conviction in the Magistrates' Court, there is an automatic right to appeal. Appeal against conviction on the grounds that the conviction went against the weight of the evidence, and or appeal a sentence on the ground that the sentence is manifestly excessive. The other matter to consider at court with, or even before court with benefit frauds, is the question of interview under caution. Now, what frequently happens is that a person who has claimed benefit or is in receipt of benefit in the past will be subject to an investigation and will be invited to attend a local job centre or some other building for an interview under caution. The attendance at that interview is voluntary, so you're not under arrest. You don't need to attend, but frequently people do attend. They decide that they're going to go along even though they don't have to, and submit themselves to interview under caution. The caution is you do not have to say anything, but it may harm your defence if you fail to mention, when questioned, something that you later rely on in court. Anything that you do say may be given in evidence. What that effectively means is that anything that is said, anything that is put to a person, can then be used in evidence against them at court. And frequently it seems people don't understand that by voluntarily going into interview or going in without representation, without a solicitor present with them, it will strengthen any potential prosecution evidence against them. So, if somebody you know is under investigation by either the local authority for housing benefit, or by the Department of Work and Pensions for income support or job seekers allowance or something of that nature, bear in mind you don't have to go for interview under caution, you don't have to voluntarily go along. Of course, there's a possibility that the investigator might then ask for an arrest from the police. That's obviously a decision that has to be made. Whether the police will be prepared to involve themselves in that matter or not is debatable. And also, if you are to go along, if you do decide to go along, then take a solicitor with you and go along and receive legal advice, because the decision whether to make no comment, answer questions, or make a prepared statement is very important. It can substantially affect the outcome of any interview and any decision to prosecute thereafter.